The next item of business has to do with Appeal 2925. The applicant Gary E. and Christine F. McLean, property located at 404 West Wayne Avenue and Zone C1. Request a hearing regarding an enforcement notice of Radnor Township dated July 31, 2014. Applicant requests relief on one or more grounds, including the following. 1, that the property is a non-conforming use. 2, variance by estoppel. 3, special exception pursuant to Section 280-45J2. And 4, a variance under Section 280-101. Now, we've been advised through our solicitor by means of the counsel to the parties that the parties have consented, mutually agreed to a continuance of this case. So we're going to continue it to the November meeting. The township is automatically a party to that case, and the appropriate person to be present for the hearing had a family emergency, which prevented him from being here tonight. So by agreement of the parties, it is continued till November. Now, John, do we have a copy of that letter to put in the official file, or? Without my vice chairman here today, I'll just throw that in there because I can't keep up with the filing myself while I'm talking.
The letter that is between the files from the township solicitor is advising us that the parties agree with
No, the letter we have is from the township solicitor dated today, just stating that the parties have agreed to the continuance, and so this is continued and will not need to be re-advertised.
Okay, from the agenda, the next item of business is Appeal Number 2926, 2 Canterbury Lane. The applicant Duncork Inc., DBA Bradley Construction, property located at 2 Canterbury Lane and zoned R3, seeks a special exception for an extension of nonconforming use pursuant to Section 280-101 of the zoning code, or in the alternative, a variance from the setback provisions of Section 280-27 from 10 feet to 5.46 feet. Who's here representing the applicant?
Good evening, Chairman Cutler. Patrick Hennigan from the firm of Eccles, Sparks and Media on behalf of the applicant. With me this evening, I have the owner of the property, David Roush, and also the representative of Duncork, who is a contractor, Brendan Bradley. As set forth in our application and the documents that were attached thereto, this is really a matter of inches in terms of this project. The Roush property had an existing garage on the property that was in disrepair and was falling apart. In order to improve the property as well as to protect the integrity of the neighborhood and the safety of everyone, Mr. Roush decided to reconstruct the garage on the original footprint of the garage and started the process. During the course of the construction, there was a complaint made that, in fact, the footers for the garage extended 6 inches, I believe the survey report is, beyond where the original garage may have been constructed. We believe that that is a mismeasurement, but we're seeking a special exemption to enlarge the existing non-conforming use for that matter of inches so that Mr. Roush may reconstruct the garage and improve his property and the neighborhood property. So Mr. Bradley is able to discuss more of the...
Yeah, I didn't understand that from your application. I was thinking that you were replacing it where it was.
We are.
And you think you are, and someone thinks you're not.
Correct. And there was a letter issued by the original architect that I don't believe was part of the application, that if I may
Surely.
approach.
There's a preliminary issue. Let me tell you what it is before we start taking exhibits and things. If you were repairing something that was already there in a non-conforming, you're not a non-conforming use, you're a non-conforming structure, because the use is permitted. You're allowed to have a garage on the residential property associated with the principal residence. If you're a non-conforming structure, you're talking about our section 101B1. That does not require a special exception, as long as you show that you qualify under the facts that you are repairing what was already there, where it was, or not making it worse. You could even extend it, but as long as you're not increasing the degree of nonconformity, you would not need relief from the board. So all you'd need to put into evidence would be the facts that it is not getting any closer to any sideline than it was before, and you're repairing what was already there, and there'd be nothing else for any of us to do. We get that on the record. If, on the other hand, you're actually increasing the degree of nonconformity, then you would need a variance, not a special exception.
We would seek the variance regarding the expansion of this nonconforming structure as opposed to the nonconforming use.
And your variance is a matter of 6 inches?
Yes,
Nothing more than that?
that's correct.
Mr. Chairman, if they have extended by 6 inches, then I agree that they're out of the 101B1 special exception, but it would be permissible for this board to consider a de minimis variance for 6 inches. The board is not required to grant de minimis variances, but it may grant de minimis variances in its discretion.
Now, is this only as to one of the dimensions? I know you're closer than existing zoning allows to 2 lines.
Correct.
Is there any question about both lines or just one of the lines?
Just the one line.
Okay.
And as Mr. Bradley will describe, the structure lines up exactly with the existing driveway, exactly as the prior
Right.
structure did.
Okay.
And you had the first floor is built already?
That's correct, yes.
Yeah. And it was just laid on the existing foundation?
Yes,
Okay, but there was just maybe 6 inches of overlap.
correct, yes.
The existing
Don,
foundation
could-
is just slab on grade.
could you take care of labeling the exhibits?
foundation is
Surely.
At least a little bit of the overlap.
Okay. Yeah, I know.
Sorry, I didn't hear your, actually,
Wait,
I don't know. you've
he hasn't been sworn yet, and he hasn't
Yes.
come to the
Yeah,
mic.
We have to, yeah.
We're just figuring out whether we're dealing with this as a variance matter, a special exception matter, or nothing at all except getting facts on the record to decide he's doing this as a matter of right. So since we've decided we need to do something, let's go over and label the exhibits you've already
You want
put
to swear
in.
them in first? And-
What, you know what the exhibits?
Fine, I don't, it doesn't matter. What exhibits, the exhibits that I have right now are an application packet that's got photos and it's got the plot plan, and then you have a deed. Should we just label the application with its various attachments, since they're all stapled together, as A1 and the deed is A2?
Okay, then on the record, I guess we should show that attached to the application is a letter of August 21, 2014 from Yerkes Associates, Inc., a copy of a letter from Ronald Seaboth, architect, addressed to, curiously, it's addressed to Radnor Township, Ardmore, PA. I don't know. But it is dated 8/28/14. And then there's a witness list on the back of that. And then there are what look to be construction drawings, a pack of those, and then there are a number of color photos of the property in question. So we're going to label all that A?
Unless you want to break them apart. because
Well, I don't know that there'll be any reason to. We can specify which one.
Yeah, I think this is pretty straightforward, and I can,
And the-
reference the plan.
And the deed will be B, and the deed does convey title to the property to David L. Rouch. Okay. So why don't we introduce a witness, and
Or you can swear them in
we
collectively.
just swear.
or-
Would you like one of these?
Certainly, if you don't.
There we go, it's actually on.
Also, we can vote them for just one person.
Right.
Speak over.
If you can stand
just raise your right hand. You do solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, nothing but the truth.
I do.
And state your names,
David L. Roush.
and spell.
Last name, R-A-U-C-H.
Brendan Bradley, B-R-A-D-L.
Please do it into the microphone. We have to get that, either one.
Brendan Bradley, B-R-E-N-D-A-N, B-R-A-D-L-E-Y.
Okay, proceed. You know what we need to hear, so.
Yes, actually, Mr. Bradley, can you describe the existence of the garage on Mr. Roush's property prior to engaging in any repair activities?
Yes, there was a structure approximately 20 feet wide by 24 feet long. It was in disrepair. It had two steel cables going from side to side, actually holding it together. There were two stone pillars on either side of the garage door.
Excuse me. Can you?
Hold it
A little further away?
Oh, yeah.
Ah, okay, sorry. When we originally started looking at the project, we talked about building it on the same footing. We went to the township, we discussed it, and they said, sure, bring in the plans. We moved forward. The only thing I can tell you is the one thing we stayed true to was that property line, because we knew that we were on a non-conforming lot. And Bill Miller had made that very clear from the beginning, which you will see on one of the photographs. We took a photograph of the new structure, and it shows the driveway coming right up to the corner of the new structure, which it did before to the old structure. We had the construction process well underway when we got a phone call telling us that the project had been stopped because someone had made a complaint.
Is it your understanding that the structure is being built in the same location as the existing, or the prior existing garage?
It is, yes.
Did you undertake any work to expand the structure beyond the boundary of the original structure?
To the property line, no.
Okay. Is the condition you described shown in evidence by the photographs that were supplied to the zoning board?
Yes, we also supplied photographs of whatever photographs we could find of the existing structure before, and it clearly shows the proximity to the fence. I also had, as you have the letter there from Yerkes, come out and do a full land survey. The fence is directly on the property line. And the property line does run off at an angle, so in actual fact, we really are talking 4 inches more than 6 because the property line runs off at an angle.
Thank you, Mr. Bradley.
Mr. Bradley, if I just going to ask, just in other words, your testimony is that you built the garage on that property line exactly where the original garage was. So if there was a measurement issue, it would have been there for the original structure that you replaced.
That's correct, yes.
Okay, and you would agree, though, that if there has been an intrusion, a further intrusion, which you do not believe has happened, it can't be, more than 4 to 6 inches.
That's correct, yes. Actually, what I believe happened is I believe the architect failed to get a survey done prior to it, and also failed to measure the property beforehand.
Yeah, so nothing, in your testimony, nothing has changed. We just had an earlier measurement that was off.
Absolutely nothing has changed, no.
Is the anticipated volume of the garage structure comparable, new building versus old building?
There was an extension put on the back because of they couldn't actually access their vehicle. They didn't have enough length, so it was lengthened, but it was lengthened with the township's okay. I believe it's a 10-foot setback, and we're 12 and a half feet, so we're.
But just to confirm, it's a traditional garage. It's on the second floor storage
It has,
space.
what has happened is the roof line has been changed to match the house. The house has 3 dormers coming across the front, and the roof line was changed to add 2 dormers, just to add, basically from an aesthetic standpoint, to the property. That was it.
The height of the new garage and the old garage are the same?
There may be, actually, I'm not sure about that now. I have to be honest. I'm not,
But you're not asking for relief with regard to height,
no,
right?
no,
Or with regard to the distance from the rear line?
no.
Oh, so they're really not asking for that. Actually, even if they changed the use, I think under Radnor Township zoning appeals, even if they were changing the use, as long as it increased in nonconformity, they would be okay.
Yeah.
Yeah. That involved the case right across the street from where I live. That's why I remember it, even though I'm long retired.
So I understand the facts correctly. Work commenced after consultation with the township as to the placement of the footings. And then subsequently, the township changed its mind in terms of,
No. The township were fine. The township issued the permits.
right,
We had the township out for footing inspections. We had the township out for, we also had a stormwater management test done, and they came out, they okayed that. We gave them all that paperwork. We had the first floor up, and one of the neighbors come over and said, "You can't build that there." And we're like, "Well, yeah, we have a permit." She left, and 2 hours later, Bill came by and said, "Sorry, I got to stop you." So that's how that transpired.
okay, because I'm struggling with, if you're reconstructing the garage on the very footprint that originally stood, we have one set of facts in front of us. But if that has changed and it truly is not on the same footprint, then I assume that we have a variance of some type that we're being asked to consider. But reconstruction on the same location would be by right.
Yeah, that would be
wouldn't
by
it?
right.
Yes, and the fact that they've
So I'm
extended it.
I'm still struggling with the facts. If you're asking for a prophylactic variance, just in case it moved, I mean, are we in that business? I don't know. I mean,
it
we
would be a-
need to find the facts first, right?
Yeah, I think you could do that if the board wished to do that, but what I understand is the problem here is that the set of plans that came into the township, according to the testimony, had an erroneous measurement. The architect did the measurement and got it wrong by a few inches. And then when they, the plans upon which this were built, and it was then measured and found that you were 4 to 6 inches further into the yard than the plans were, and then Yerkes came out and measured it, and presumably Yerkes got it right. But there's never, in terms of where the original garage was, the testimony is that it was built on the original footprint and hasn't gone over that footprint by millimeters.
Right.
As to these lines, not as to the back where they have no problem.
Right.
Yeah, and thank you, John, for that. But again, whether they're the right set of drawings or the wrong set of drawings, or the error was in the set of drawings, if the presumption is that it's still on the same footprint, regardless of where that footprint happens to fall, why are we?
Well, that's right.
Why are we
that's the
being asked for a
testimony.
variance?
I think, I tried to figure this out myself beforehand when I reviewed the file. What I'm thinking is this, that because the building has already been taken down, there's no way now for the township to verify that it's the same distance from the structure that was already there.
But
Now-
wouldn't the granting of the permit answer that question?
Well, the question
Because the
is,
presumption there is
if the
that it
drawings-
complies with all zoning.
but the question is, if the drawings were inaccurate in their facts, does that go to the validity of the granting of the permit?
If I
What
may
they're
add-
saying is, it was an inaccurate measurement. It's right exactly where it was supposed to be, is what their testimony is.
Right.
And the only reason why it seems that there's a discrepancy, which is a small one, is because the architect or whoever did that did not actually field verify the measurement before they got the permit and took down the structure.
So this is really belt and braces as opposed
Yeah.
to, a
And the
real.
township has.
So, I mean, but your testimony is that it's exactly where it was, except as to the rear line where you don't have a problem anyway.
That is correct.
Well, if that's the testimony, and if we don't wind up with any contrary testimony, then I think we can hold that it's a 101B1 situation and that they're entitled to do it as a matter of right as
Yeah.
to this issue.
But now switching hats, the township stopped work. So what do we make of that? There's no one here from the township to inquire of.
Well, it's our job to hear the appeal, and if we said they wrongfully stopped work, then that's rescinded
If
by
I
our
may,
order.
I will tell you this, that everyone from Mary Ann to Bill Miller basically walked me through this whole process because they knew what the situation was. And the situation was that someone came over and complained. We did everything by the book. Bill actually even made a suggestion that I argue that the building was leaning so far to one side, which it was, that there's your 4 inches. But I said, so yeah, exactly. But my point being that basically we have done everything hand in hand with the township. And Bill actually told me that I would get no objection from him because he knew we had followed the footprint.
Okay, well, what we'll do is, at the conclusion of the case, and we'll see if anybody wants to put testimony on from the audience, we'll see if there's any contrary testimony to figure out which way we deal with disposing of this. But,
If I may ask Mr. Roush, just one quick. Mr. Roush, have you inquired into your neighbors as to whether they have any objections?
I have 3 of them.
Okay. And did you obtain statements from the
I
3?
did.
Can you just identify the number or the neighbors that you received these letters from?
Rachel Ebby Rosen, who lives directly behind me.
sir, please speak into the microphone.
Sorry. Rachel Edney Rosen, who lives directly behind me, and her husband too as well. Robert Kelly, who lives right across the street from me, and P.J. Kohler, who is my next door neighbor, actually the one whose property line it affects, have all basically said in regards to the garage. We live in the adjoining house. We see the garage. We believe it's stayed on the exact same.
She's trying to take down every word,
I'm sorry.
literally.
They state that the garage is located on the exact same location to their knowledge.
Okay, now, who was the complaining party?
It is the coffee residence, which is.
Have to use the microphone, sir.
Sorry. It is
We
the
have people at home watching us. believe it.
Okay. It's the coffee resident, 2 people, probably my wife who wants to know whether this is going to get approved or not. It's the coffee resident, which is sort of diagonal from our house. If you look across Canterbury Lane to our neighbor and then up one to the right. They are the complaining neighbors. I will say they've never stepped foot on our property. They've never asked to see plans. They've never asked for anything, really.
In the plans you submitted to us, is there anything that shows these distances accurately? I mean, should we have to go the variance route, do we have something we can refer to that's quite specific?
The Yerkes survey that is attached to the application is the actual measurements from a field survey.
Well, let's see if we can find that. I have a Yerkes letter,
That's it, of August 21st.
and then I have a site plan. So in other words, it's not on a plan attached to the application, but it's mentioned in the letter.
Correct.
Let's see how
Correct.
specific they are. Maybe we ought to read that into the record, and, shall I do it, John?
It's in the record already, and it just simply says that it's 5.46 and that he measured it. What it doesn't say is
It's the same as it was before,
four.
because he wasn't out there before. Yeah.
Correct.
Now, the architect plan, does that show the distance from the property line?
Well, I guess what we could do, John, is we could, if we had the grant variance relief and chose to do that by vote, then we could refer to this letter as the limitations and the definition
you
of
absolutely
variance.
could do that.
Instead of the plan. So that could be done. So we do have something adequate should we decide to go that route and need to. Okay. Any other questions? Do you have any other evidence you want to present?
I would just like to supplement the record with the letters that were identified by Mr. Roush.
Do we have copies of them?
Yes.
Okay.
We can enter those in as A3, an A4, and A5. Doesn't matter which order.
Well, isn't A the application and B the, B is the,
No, it's A1, and A2, and then it's applicant. These are, in other words, we
oh,
have
I see,
two.
we didn't lay, maybe, one, two, okay, right, sorry.
Oh, okay. You know, why
I
don't
have a
you
problem
just
with
make-
alphanumerics, you know, I get,
Mr. Chairman, they're all stapled together. Why don't we just put them all in as A3 rather than breaking the staples out?
is that the
That's the
case?
extent, yes, of our request.
And you would move that your exhibits be made part of the record?
Yes, I would. Thank you.
Now, is anyone else present who wants to be heard on this matter? No? It's either the two of you or no one. Okay. Well, then, we've had all the evidence in the record we're going to get. Chair will entertain this motion.
Mr. Chairman, before we do that, my position is that I'm not convinced that a variance is required here, and that the relief that's granted goes beyond what is really necessary to address the situation.
A technical question, John. If we decide that that's the case, that no variance relief is required and they're entitled to do this as a matter of right, in what form do we do this so that the township can be shown something and lift the stop work order?
It's you issue an order, and the order would be, based on the evidence of the record, the garage as to that property line was built in the exact same place as the prior non-conforming garage. Therefore, relief is variance relief is not, or special exception relief is not necessary, and the order suspending work is reversed. Period.
And then should we also incorporate the Yerkes letter and say that, providing they build to those distances?
Yeah, that'd be fine.
As a limitation, no
Yeah.
closer?
Well, haven't they already built to those?
Yes.
Well, yes, but there's always the question of a tear down order now, isn't there? So we want to, okay, does somebody want to just incorporate what John said by reference and make a motion?
I move by incorporating the observations of the solicitor by reference that we approve an order that states that the work may proceed by right, and that the stop work order should be rescinded.
Up to the conditions and limitations discussed. Okay, any seconds?
Second.
All in favor, say aye.
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 Opposed? No one? Okay. Thank you, gentlemen.
Thank you. Thank you.
And that's our business for today. Nothing else in front of the meeting. See you in November. We won't see you in November, but...
Have a good night, guys. Thank you.
Thank you, gentlemen.